Assalamu alaikum and welcome to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. As always, I'm here to assist you with any legal queries that you have in relation to any fields of English and Welsh law. You can participate in this show in one of two ways. Either you can call the studio on the landline number which you find at the bottom of your screen and speak to me directly in the studio. Alternatively, if you wish to present a question but do not wish to speak live on air, then you may want to send your message through the mobile number, again, that you see at the bottom of your screen. What I ask is that you provide sufficient detail within the question you are presenting to allow me to understand what your query is and how to best address that. If I am missing any details which prevent me from answering your question, I may ask you to send a follow-up question just to provide some additional details. I will, of course, provide any generic advice just to give you some guidance in terms of the query that, as I understand it. Please refrain from identifying any individuals within your questions. We like to provide this service in a confidential manner, and it can benefit both the questioner and also our viewers who may have a similar query or question. There are some questions that we have left over from last week. I will therefore proceed to answer those, and I ask for your forgiveness that I didn't get around to those at that point. There was a question asking about the timeframes for applications in relation to naturalization applications following the biometric enrolment process. At the moment, these applications are taking up to 6 months, some slightly longer. But overall, my experience is that it's not much longer than 6 months. Some are coming through a little bit quicker. It depends on who's looking at them, how complex the application is, and whether or not the nationality teams require any additional information from you. But the better the prepared the application, the quicker the decision, because if you make the Home Office's job easier, that they will then work through that a lot more quickly. I hope that answers your question. There was another question in relation to visitor visas who have been refused. It's a partial question, and I'm not sure if that was in response to something that I said in last week's show. With regards to visit visa applications, a refusal unfortunately does not give you a right of appeal unless it has a linked human rights element to it, and that was argued at the time of application. If there is no right of appeal, which is the vast majority of visit visa refusals, then your other avenue of redress is to challenge the legality and the reasonableness of the refusal through a judicial review. For those of you who regularly watch this show, you will note my air of caution in respect of judicial review proceedings and when they should be utilised. Generally, with visit visa applications also, if there's a refusal, it's usually quicker to make a new application. It's also significantly cheaper to make a fresh application addressing the points of refusal. So it will be rare that you would need to seek redress through the judicial review process. You may need to judicially review if there's been several refusals. You're not getting beyond the point where you are putting in fresh evidence with the follow-up applications, and the Home Office is still not accepting those. But generally, most people will find that if they address the reasons for refusal, submit the additional evidence, then they will have a better outcome. Also, please don't fall into the false sense that just because the Home Office has not raised an issue in the previous application, it will not raise it in the subsequent application. So, for example, if you are making a visit application and the Home Office has refused it on the basis that there is limited evidence of the applicant's financial circumstances, does not necessarily mean that in a subsequent application, if those concerns are addressed, the Home Office will not raise another point of refusal. So, for example, they may, in a subsequent application, the Home Office may deem the accommodation to be inappropriate, or it may deem that there is another reason why this visit is not a genuine visit, and demonstrates that the applicant will not leave. So the subsequent applications do still need to be fully prepared, not simply the same applications addressing the reasons for refusal in the previous application, because that could then lead to further points of refusal. So again, prepare it afresh, make sure that all the requirements are met, including the requirement with which the Home Office previously raised any issues. So I hope that assists and gives you some kind of guidance as to how to progress from that point. There is another matter that I wish to educate you about today, and this affects a lot of our viewers. We've previously had a large quantity of questions around this field, and that is individuals who are currently on a 10-year route to settlement, usually on a parent or partner route, but where there are children involved. And they have subsequently made an application under what is commonly known as the Zambrano route. Zambrano refers to a case name in which the courts were tasked with looking at the rights of European children and the impact of those European children should a parent be required to leave, and whether that would then mean that the European child, which included British children, would then be required to follow and would therefore be deprived of their British or their European rights as citizens of those respective countries. And there has been much debate around whether individuals who are primary carers for British children post the Brexit arrangements can rely on the Zambrano principles to seek leave to remain in the United Kingdom under the Appendix EU regulations, or the Appendix EU part of the immigration rules, as opposed to the European regulations as they were previously. There was case law around this, and it was a mixed judgment, but overall the courts accepted the appellant's view that the Home Office was wrong in denying denying parents of British children the right to apply under Appendix FM and to take benefit of these regulations. Generally, these refusals were on the basis that the parent either had the 10-year route to leave or the 5-year leave route to settlement under the immigration rules, or they were eligible to apply under those routes, and therefore they were not entitled to apply under Zambrano. Now, the Home Office agreed to review its policy following that case law, because when the Appendix EU was drafted, it did not reflect the court's judgment, and the Home Office had agreed to review that policy. It had a deadline in May to do so. It failed to meet that deadline and requested an extension. That deadline has now also passed, and I believe the Home Office has requested a further extension, and I believe that extension now is up until the 15th of June. So again, there's no certainty around those applications. Many of you are still in limbo waiting for the outcome of those, and so that's the position. And if you're wondering why there is a delay, that there's delays across the Home Office in any event, as we've discussed over the last few shows. The added delay in any Zambrano applications is the Home Office doesn't actually have a policy and is still, we're told, in the process of reviewing that policy, and has now been afforded an extension, or is certainly seeking an extension until mid-June to review the policy and to come up either with a revised policy or whatever it may decide to do as a consequence of that. So that's the position with Zambrano applications if you are waiting for an outcome and wondering why there is a significant delay. The other aspect that we've had at the moment is a lot of questions around delays for spouse applications and entry clearance for spouses coming into the United Kingdom. We have recently been informed that the time frame for processing those applications has now increased from 12 weeks to 24 weeks. So in essence, it's doubled. And that's a consequence of the Ukraine crisis in which those applications are being prioritised for Ukrainian visas. And so unfortunately, other applications are being delayed at the moment. So again, if you are an individual who is waiting for a decision in respect of a spouse application and wondering why it's taking a significantly longer period than you anticipated, that's your answer, unfortunately. There's very little that you will be able to do at this point. If there are any compelling or exceptional circumstances in your case that require the application to be expedited, then that's something that you may wish to explore with the entry clearance office and with the Home Office directly. But those would have to be significant compelling circumstances, because the Home Office position will be your case is not unique in comparison with anybody else's. And if everybody else is having to wait up to 24 weeks, then unfortunately you, barring these exceptional circumstances, will also need to wait. So those are some of the developments in the recent kind of weeks. And again, the theme stays the same, unfortunately. Is still news of delays, news around, applications not being processed, the uncertainty around people's right to reside and the impact that has on right to work, etc. I will return after this short break and continue providing some additional information. Inshallah, join me then with your questions. Assalamu alaikum wa rahmatullah. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. Thank you for joining me after that short break, and I will continue to take your questions and try and guide you and provide as much assistance as I am able to do so with regards to them. We have received through the break some more questions, and inshallah I will pick them up as we go along. The first question relates to an immigration matter with regards to 10-year long residence and whether an individual who has resided in the UK for a 10-year period and has held lawful residence during that period, whether they can apply for indefinite leave to remain, or whether they can apply for leave to remain. And the short answer to that question is yes, they can. If an individual has accrued 10 years lawful residence in the United Kingdom and that has been continuous, then the individual is eligible to apply for indefinite leave to remain on that basis. Like any application made to the Home Office, the lawful residence will need to be evidenced through official sources where possible. The Home Office will accept some unofficial sources where there may be gaps, but to make the application more likely to succeed and a stronger application, then it's advisable that you do try and seek evidence which is from independent and official sources, because it then provides stronger corroboration and more weight is given to that type of evidence. So in regards to the 10-year lawful residence route, what you're looking for is a continuation. Now, if there are periods where, for example, you were waiting for an application, so for instance, an individual has arrived in the United Kingdom as a student, for example, that visa is due to expire and an application is submitted before the student leave finishes, to either apply for further leave as a student or further leave in a different category, then the duration that individual is waiting for the decision is also lawful residence, because when an application is made by an individual who has extant leave, who has valid leave, and a further application is made, the law effectively extends that period of leave, so that continues until the Home Office makes a decision. And if that's a positive decision, then that's fine. You carry on. Now, if that's a negative decision and the individual is given a right of appeal, again, as long as that appeal is exercised within the correct time frame, that leave again then continues until the court's determination, and then any subsequent leave arising from that. The best way to look at these is to collate all of the evidence that you have in relation to past visa applications. What periods of leave have you had? Are there any gaps? And if there are any gaps, then you need to be wary. You need to work from the point where you then started again. So effectively, if your lawful residence is broken, so if you take the example of the student who's been here in the United Kingdom for 12 months, they then submit a valid application before that student leave expires, and they have that's refused. They have a right of appeal, but the appeal is lodged late, be it a day, be it 2 days, be it a week. That lawful residence is now broken. So the court may still, the tribunal service may still admit the appeal, and the tribunal service may allow that time to be extended so that the appeal can continue, but that does not bridge the break in your lawful residence. So in essence, what will then happen is you are an overstayer for that period until you are then granted leave, either through the court's determination granting you leave or any further applications. And so when you start calculating the 10 years lawful residence, you would start at the commencement, at the beginning of that period of leave, the second period of leave, which is then lawful, not the first, because there was a gap. And just because the appeal has then allowed you further leave does not, unfortunately, mitigate for that break. So do bear that in mind. These applications are not cheap. Currently, the Home Office fees are £2,404. That doesn't include any other kind of fees that you're paying for the solicitor and anything else that comes into that. And so they're not the cheapest of applications to make. You don't want to lose your fee because you've not calculated the 10-year lawful residence period correctly. The other reason we see a lot of these applications being refused, particularly where individuals have submitted them themselves, is where the application is submitted too early. So the 10-year lawful residence, 10 years are on the 1st of June, for example, and the application is submitted on the 30th of May or the 28th of May. Even though it's a short period, you still made the application too soon. And again, that could lead to a refusal because you had not, at the date of application, completed 10 years lawful residence. You were short, be it a day or two, but you don't meet the requirements. So again, be careful to calculate. If you're unsure about any breaks in your lawful residence, the best way to do that is to try and gather together as much documentary evidence you have for your past applications. You can do that by requesting files from your previous solicitors. You may have some of these at home. Bear in mind, solicitors only retain files for a period of 6 years. After that, we are required to destroy them securely. So, if you are looking for a file that predates your 6-year period, then you won't find that from your legal representative. The way you would then obtain that information is making a subject access request to the Home Office, and they will, the Home Office will then process that, and it will send you a copy of your file. As anything with the Home Office, unfortunately, you are not going to receive that disclosure in line with the data protection regulations, which requires the Home Office to disclose any information within 1 calendar month. You're probably looking more like 6 to 7 calendar months before you see any of your information. So do bear that in mind when you are looking for that evidence. So that's the lawful residence. Bear in mind you will need the English language. That's a basic requirement for indefinite leave to remain, and for indefinite leave to remain that is at level B1. So again, make sure you do have that. Absence of the English language will mean that your application again does not meet the requirements, and you will therefore be refused again. Seek advice. That key always. No 2 cases are the same, and you will have heard me say this repeatedly. No 2 cases are the same, and it's really vitally important that you are seeking specialist advice that's tailored to your particular circumstances to give you the best chance of success. These things can go wrong, and they can go dramatically wrong for you. And the cost of putting them right far exceeds anything you will save by doing the application yourself at initial stages. So unless you are absolutely confident you know what you're doing, then please get some legal advice to ensure that you're protected and your legal position is protected. Because if you are in that position and you are making an application, you do risk losing the lawful residence if your application is then invalid or refused. So the consequences can be quite dire. You don't want to be starting your 10-year lawful residence after having completed 10-year lawful residence. So I hope that gives you some guidance in terms of what the requirements are. There are requirements in terms of the period of time that you may have spent outside of the UK as well. So be sure to calculate that correctly. If you have been outside of the UK for longer than is permitted by the immigration rules for this particular category, then you may want to wait a little bit longer before that you are compliant with that particular requirement as well. So just to recap and to run through some of the requirements. So first and the most obvious is that you have lived in the UK both lawfully and continuously for at least 10 years. Please do remember you need to have completed the full 10 years at the date of application. So don't make an application a day early or a week early or a month early. That doesn't apply to lawful residence applications on 10 years. You needed to have completed at the date. You need to show proof, obviously, that you've been in the United Kingdom. And generally it's a good idea to show a selection from each of the years. Think about the proof that you are presenting also. If you have a letter, for instance, from your GP that simply says this individual has been registered at the surgery since whatever year it might be and whichever month of that year it might be, that doesn't help the Home Office assess whether or not you were in the UK for that period. It just simply means that you were registered with the GP for that period. Your name was on their register, essentially. So you would need more than just that. So look at the quality of the supporting evidence in addition to the quantity, and quality always takes precedent over the quantity. English language proficiency, I've discussed that. Most of you will know that unless you hold a degree that's been taught in English, then you will need to provide evidence of passing an approved Home Office English language test. GCSEs, A-levels, unfortunately, are not evidence of English language proficiency. You either have a degree and that level in English, or you take the test even if you hold GCSE or A-level English qualifications. Life in the UK test. Again, that's something that you do need to take for the indefinite leave to remain. So that's something else that you will need in place before you make that application. So I hope that helps you in making those applications. Inshallah, we are going to proceed once again to a short break. Please do keep your questions coming in, and I will endeavour to pick them up and go through them as thoroughly as I am able to. If I do miss anything, then please come back to me. Inshallah, I will see you on the other side of this break. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. We are in the penultimate segment of the show, so please do keep your questions coming through. And sooner, if you do want them answered in the show tonight. Otherwise, I may not get around to them today, and they may need to wait either for the show tomorrow with Mr. Ilyas Bulbulia, or if you would like me to answer them, and then next show on Monday. Before we went to break, we received a question in relation to bare trusts. Thank you so much for sending this question through. The question is, can a bare trust deed written by two parties, so a trustee and a beneficiary, is it liable to capital gains tax based on the trust deed? Is the trustee liable to pay tax on the rental income? So there's two parts to that question. And now I do start by saying that I am not, it's not a field that I practice in. My understanding within the tax field is quite limited, so I would advise you to seek some specialist advice. But my understanding is this. So a bare trust, for our viewers that don't know, is a trust that's usually held for another individual. Usually, these types of trusts are held by an adult for a child. So a parent may hold assets on behalf of their child until the child achieves the age of 18 for the purposes of England and Wales, and for Scotland, the age of 16. The beneficiary, so the person who's going to receive those assets, I mean, in my example, the child, can access the assets within that trust at those ages, so 18 within England or 16 within Scotland. So that's what the bare trust is. So in our question, we have a trustee, so an individual who's holding assets for a beneficiary. I don't know the age of the beneficiary, but the question is, are they liable for capital gains tax? Now, capital gain tax is a tax on profit. So it's when something, an asset, that increases in value. That's when an individual is liable to pay capital gains tax. Now, in a trust situation, if assets are put in a trust, then tax is paid by either the person who is selling the asset to the trust or transferring the asset to a settler. Now, if the assets are simply transferred from the to the beneficiary, then at that point there is no capital gains tax, because there's no kind of added value there. So if the transfer is simply to the beneficiary, there's no capital gains. If, however, the assets are sold on behalf of the beneficiary, then there is capital gains payable. So I hope that answers your question. But as I say, not a field I'm particularly confident with. And so I hope that I've guided you in the right direction. But my advice would be seek also some additional specialist advice from a tax advisor. Again, if you have any follow-up in relation to that, then please do follow that through with additional information. Sorry, forgive me, there was another part to your question in terms of the tax on these types of trusts, and whether that would need to be paid on the rental income. I'm not sure. There are other types of trusts where there is a tax liability. Whether that's the same for bare trusts, I'm not unfortunately able to answer that. So again, as I say, if you do seek some specialist advice, then you will be better guided. I don't want to misguide you in that respect, but certainly in terms of what a bare trust is, hopefully our viewers are now familiar with that. And the capital gains liability, if it's a simple transfer to the beneficiary, then there is no capital gains to be paid. It's only if that those assets are sold either by the beneficiary or on behalf of the beneficiary. So that was the question in regards to trusts, and I do beg your pardon that I wasn't able to give you the fullest of answers, but thank you for taking the time to send that through to us. Now, with regards to some further questions, let's see what we have. Do excuse me whilst I just sift through some of these for you. Now, we have a question here with regards to employment tribunals, and when a case or how a case can be started at the employment tribunal. With regards to employment tribunal cases, you need to follow certain processes, and the jurisdiction that an employment tribunal has is quite limited. So initially you need to establish that there is an employer-employee relationship, and that's quite important, because if the relationship is not that of an employer-employee, then the employment tribunal may not have jurisdiction. You may need to be approaching a different court to seek the remedy that you are seeking. Now, if you feel that you have been treated unlawfully by an employer, a potential employer, or even a trade union, then you may take your case to the employment tribunal. Unlawful treatment can include unfair dismissal, it can be discrimination, or unfair deductions from your pay. Bear in mind that usually you will need to bring a claim within 3 months. So quite a tight deadline there. So always be aware that's when you bring the claim. Again, it's from the employment ending or the problem happening. So again, be aware of when your deadline starts, so that you can correctly calculate that 3-month deadline. But again, always be aware of what timeframes you're working towards. Be aware of anything that will impact on those timeframes being met, so that you can take remedial action for those before the problem arises. Now, you will have heard me mention previously the organisation called ACAS. ACAS are an advisory, conciliation and arbitration service, and you do need to tell ACAS that you are intending to make this claim to the tribunal. At this point, ACAS will offer you the chance to try and settle the dispute without going to a tribunal. And this is known as the Early Reconciliation Service, and it is free of charge. So it may be that you can resolve the dispute without having to go through the tribunal. It is free, it doesn't cost you anything, and it takes away a lot of the stress of presenting your case before a tribunal. And by the time you get to the tribunal, you know, a bad situation has already become worse. So that's ACAS, and those numbers are widely available. So ACAS, if you Google that or use any of the search engine, then you will be able to find their contact details. And like any other office, they are open Monday to Friday. I think their opening hours are slightly longer than normal office hours, usually between 8 a.m. and 6 p.m. But you should be able to contact them in some way. If you are a member of a trade union and your dispute isn't against that trade union, then you may want to seek their assistance. And of course, you're always entitled to seek legal advice in relation to your claim from a solicitor. So those options are still available to you. With regards to employment tribunal claims, they are made online. And there is guidance available, and again, widely available. If you just simply search for that, you can look on the Employment Tribunal website. And again, a lot of the guidance is available there. You also have the option of making the claim by post. Rarely done, but if you're not able to make it online, then that option is available. And again, you will find the address on the tribunal website that helps you send that through. As with anything, if you are sending official documents, do send them by tracked post, so either recorded delivery or special delivery, and retain the evidence that has been sent. There is a talk-through service provided by the Employment Tribunal, and that's for individuals who are not able to use a computer. But you will need your ACAS number or a valid reason as to why you haven't got one. So an ACAS number is when you've gone through the reconciliation or you have contacted ACAS and you've either gone through reconciliation or there's been a reason why you don't want to go through reconciliation. They will issue you with a certificate that will usually then have a reference number on there, and the Employment Tribunal will want evidence that you have attempted to either reconcile or you've at least sought guidance from ACAS before you are proceeding to litigate on this matter. And the tribunal will also ask you for some background information about the nature of your claim and any kind of dates and people involved. So do you have that ready if that is a service that you are wanting to access? What happens after you've lodged the complaint? That the information is then sent to the respondent being the other party. You of course would be the claimant in the case, and so the respondent will then be given time to respond to your claim, and the time limit for that is 28 days. So the respondent has the chance to consider the information you've provided to the Employment Tribunal, and then to provide a reply to that. Once they've replied, the tribunal will decide whether they need to go to a full hearing. If they don't reply, then the tribunal may just decide the case without a hearing. That brings us to the final seconds of the penultimate segment. Please do join me on the other side of this break, where I will continue to answer your questions. Inshallah, I will see you then. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain. During the break, we've received some further questions, and thank you for taking the time to send those through. This is, as I say, the final segment, so if you are wanting a question answered, please do send it through now so that it can be picked up and answered before the end of the show. Anything that I don't get around to this evening, I do ask for your forgiveness. I will keep those questions and answer them in the show next Monday from 7 o'clock. If the questions are urgent and you do want an answer sooner, then please tune in tomorrow for the Free Legal Advice Show with Mr. Ilyas Bulbulia, and he will be able to address those for you. So the question I have is in relation to an immigration matter. So the question is, my question is, I had indefinite leave to remain as a refugee since 26 May 2021. can I apply for citizenship on 27 May 2022, as I have already prepared the application and I'm just waiting for that day, or can I wait longer than that? So the question is in relation to applying for British citizenship. This questioner has had they've completed their 5 years refugee status, and then after the 5 years, refugees are entitled to apply for settlement, so indefinite leave to remain, if the situation in the country they come from has not improved or the circumstances of the risk prevail. The questioner has been granted indefinite leave to remain and will have completed 12 months of indefinite leave on the 27th of May. And the question is whether they can submit the application for citizenship on that date, or whether they can wait longer. Well, with regards to waiting longer, you can apply for citizenship whenever you want after meeting the eligibility criteria. So should you wish to wait longer and not apply once you've completed the 12 months indefinite leave to remain, then that's an option available to you. There's no requirement that you must apply for citizenship. Now, with regards to can you apply on the 27th of May, the criteria for naturalization as a British citizenship as follows. You need to have completed 5 years residence in the United Kingdom, 5 years lawful residence in the United Kingdom. You need to have had at least 12 months worth of indefinite leave to remain in the 12 months preceding your application, which on the 27th of May 2022 you will have had. There are also additional requirements, however. There are requirements around the number of days that you have been absent from the UK, so you do need to look at those. The requirements are broken down in no more than a certain amount of days within the last 12 months and no more than a certain number of days within the last 5 years. So ensure that you do meet those residency requirements. They are important. There are also requirements around suitability, and we are seeing more and more refusals around this suitability criteria, and these may be something that you want to seek legal advice on before submitting your application. You have mentioned it's already prepared. I don't know if that's prepared by you or prepared with the assistance of a legal representative. There's that. There's the English language requirement, so please ensure you do have the right level of English language and that's evidenced correctly, and also the Life in the UK test also. So those are some of the basic requirements. With regards to suitability in naturalization applications, breaches of immigration rules are usually a cause for applications being refused. Excuse me. And one of those reasons can be either overstaying or entering the United Kingdom unlawfully. Now, we know that the vast majority of asylum seekers do enter the United Kingdom unlawfully, and there is an exception made for asylum seekers who have entered the United Kingdom unlawfully, but then have immediately claimed protection, and that protection application has been successful. So please do again ensure that you fall within that category. If you are an individual who entered the United Kingdom unlawfully, but then delayed making your application, or this isn't your first application for protection, say for instance if you were granted following a fresh claim, then you may not be eligible by simply completing the 5 years. You may then 5 years and then the 12 months, you may then need to wait until you've had 10 years residence in the United Kingdom. So there are other considerations around your circumstances before I could give you a definitive answer in terms of the chances of success. But the question you asked me directly is in respect of timescales. Can you make this application once you've completed the 12 months, subject to what I've said already and the criteria that the Home Office will consider? then if you meet that, then yes, you can make the application once you've completed the 12 months. But should you want to wait longer, then there's no harm in waiting longer either. And I hope that provides you with the guidance that you are looking for. Just on the back of that, again, there are delays in this department. So the expectation is that you're not going to get a response within the next 6 months. It may take slightly longer as well. But the best of luck with that application. And I hope it goes well for you. If you're unsure of anything else, then feel free to send up a follow-up question. If I've misunderstood your question, or if I've not answered it as thoroughly as you had anticipated, then again, please just send me some follow-up details, and I will pick those up for you. So that was another question with regards to the naturalization process. I have a number of questions around the rules around family and private life, the new rules, the changes that come in on the 20th of June. And I have addressed these in a previous program. It was announced in March, and I did go through them at that point. Obviously, we are now closer to those changes coming into force. So from the 20th of June, if you have a child who was born in the United Kingdom, and that child has been resident in the United Kingdom for at least 7 years, then they can apply for indefinite leave to remain. As many of you know, under the current regime, that child would be placed on the 10-year route to settlement along with the rest of the family. But these new rules mean that the child who's been in the United Kingdom and was born in the United Kingdom, not a child who has come to the United Kingdom, will be able to apply for indefinite leave to remain from the outset. Any child who has come to the United Kingdom and has been here for 7 years but were not born in the United Kingdom, then these rule changes allow that child to go on to the 5-year route to settlement. So it's an accelerated route to settlement, and there is the option of applying for a visa for 30 months or for the full 60 months at the outset. So there are these changes. As I say, 20th of June is the date. If you are a family in those circumstances, if you're a family on the 10-year route or even the 5-year route that are approaching your extension date, then now's the time to seek legal advice, because if you can wait and make that application after the 20th of June, you do benefit from these new provisions and these new changes coming into force. So again, just protect yourself, protect your legal positions, and particularly those of young children, because if you can achieve that settlement, then that gives that security that you and your family need for the future, and the stability for your children to go ahead. The fees at the moment, we know, have gone up recently. So fees for indefinite leave to remain, £2,404 per person. So again, it's not a cheap application to make. We know that they are significantly higher than the administration costs to the Home Office, but they are what they are, and fees, unfortunately, will need to be paid as required. But as I say, if you are in that position where you're either currently in the UK without leave, and you've got a child who has either been here for 7 years or is approaching that milestone, then do seek legal advice about your options, because they have got better, and provide that stability for you and your family. And likewise, if you are coming up to an extension, then again, discuss your options with your legal representative, because that is something that you will benefit from. The timing of your application will be vitally important. So hopefully that gives you some guidance. I will dedicate a program in the coming weeks to this, because there are significant changes. A lot of our families and viewers will find themselves in this position. So I will give a more thorough talk through Unfortunately, today is not that program. We are running out of time, but watch out for that, and I will give you some prior notice for when that show is upcoming, so that you can tune in. You can put any questions to me as and when they arise even. Just another question in terms of travel documents. Again, a lot of people concerned, unfortunately, about what's happening there. Like any other department at the Home Office, there are delays. Do make your applications and make them sooner rather than later, because, as I say, there are delays in processing times. If you are needing to, the questions generally are, can they be expedited? And unfortunately, there is no way of applying for urgent travel documents. If there are exceptional circumstances, if you are needing to travel extremely urgently, then speak to your legal representative, and they may put that to the Home Office. You may also benefit from speaking to your MP. And as I say, if there's evidence of those exceptional circumstances, if you are needing to travel due to terminal illness or for a funeral or a medical emergency, they are the type of things that can be discussed with the Home Office, and your MP and your legal representatives are the right people to speak there. We're in the final few seconds of the show. Thank you so much for joining me this evening. Inshallah, I will join you again at 7 p.m. next Monday to address some further questions. Assalamu alaikum wa rahmatullahi wa barakatuh.